We're here for our fourth and final panel of this year's conference, which is Climate Change and Human Rights. And here as our moderator is Jean-Francois Hould, who holds the position of delegate of the Quebec government office in Chicago. And by the way, that office has been a great supporter of the Canada-US Law Institute over the years. We appreciate that. Thank you very much. Jean-Francois graduated from the University of Montreal and continued his studies at Laval University and HEC Montreal. He has been serving the Quebec government in various political positions within the ministerial cabinets, including Deputy Chief of Staff and political advisor to the Quebec Minister of Culture and Chief of Staff to the Minister of International Relations. He was appointed Quebec delegate in Chicago in 2003 after serving as the director of the Quebec government office in Washington, where he was responsible for the bilateral relations between the federal government of the United States and the government of Quebec. He's here to introduce the topic of climate change and human rights from the perspective of the government of Quebec, and then he will introduce his panel and moderate the panel. Jean-Francois.
Thank you so much. Is this on? You can hear me? Thank you so much for the introduction, Stephen. I know that we are the last panel. Thank you for holding with us. We are the last obstacles between you and the happy hour this Friday and dinner. I know you had like a very great night last night. I'm here also because it's kind of my job as I never give a mic, Stephen, by the way, to a diplomat. Like we like to talk, you know. You should know about it. It's my job to brag a little bit about Quebec, but also like, and Colin introduced like this morning pretty well what the federal government is doing, but I think there's some things that are happening also at the provincial level that can worth like highlighting for this discussion today. I'm Jean-Francois, as was mentioning. The Quebec office in Chicago opened more than 50 years ago in 1969. Its objective is to promote Quebec expertise and Quebec interests in several sectors such as business, investment, government institutions, education, and culture. The office is also in charge of representing the Quebec government in several regional forums regarding the Great Lakes and the St. Lawrence River issues. Hope we're going to have the chance to talk a little bit about that. Quebec wishes to contribute actively to the action to protect this important environmental and economic asset for the United States and Canada and ensure that it continues thriving despite the numerous challenges. Let's also not forget that Quebec-US trade represents more than 70% of Quebec exports and more than 50% of Quebec's total international trade. Since we are gathered here in Cleveland, I think it's important to mention that Ohio is one of the most important trade partners in the U.S. and our largest trading partner in the Midwest, with more than $4 million in exports and almost $6 billion of trade total in 2023. Knowing it is Quebec as an office here, that should be a partner of CUSLI for so long. I think it's been a very, and I want to thank you as we end like this important conference for all the work that your team, Stephen, have done for this interesting conference. Quebec government is committed to fight climate change in all sectors of Quebec economy. Our 2030 plan for a green economy ensures that the province contributes beyond its border as well. For the government of Quebec, a just climate transition is one of which the social, the economic, and the environmental benefits and costs are distributed equally and fairly between the social stakeholders and our current and future generations. And it's kind of a core of our international engagement on the world stage. The province of Quebec always considered that what is under our jurisdictions and how we are behaving at home is also how we should behave and also engage internationally. It's called Doctrine Gérer la Joie, and it's been the core of the international engagement of the Quebec government. In 2015, Quebec declared itself bound by the Paris Agreement and committed to implement the agreement in its jurisdictions. In 2020, the Quebec government introduced the concept of just transition into one of its policies for the first time. The government listed all of the 9 principles guiding its action in the fight against climate change. Age, chronic illness, income, mobility level, social network, and risk perception are factors affecting sensitive to climate hazards and people's ability to adapt to them. Indigenous and rural populations often struggle with limited access to financial, social health, and human resources to cope with climate hazards and are more exposed to environmental disruptions. Reflecting the discussion in our previous panel, preserving the culture and tradition of the First Nation and Inuit peoples, and maintaining safe access to territories must also be considered given the impact of climate change compromise their lifestyles. Given the necessity to achieve carbon neutrality globally, Quebec has moved to the right direction, I would say, and was a leader in Canada. Indeed, Quebec provides technical support to other jurisdictions as well, in the areas of expertise such as carbon pricing and climate change adaptation. This is a significant part of Quebec's international climate cooperation efforts. Similarly, in recent years, the government of Quebec has contributed to various multilateral funds, including the Least Developed Country Fund at the United Nations Adaptation Fund, to help countries adapt to build resilience and effect in climate change. And for several years now, Quebec has supported implementing climate change mitigation and adaptation projects in certain vulnerable countries in French-speaking world in collaboration with local communities through the International Climate Cooperation Program. Let's also mention that since 2022, Quebec has been involved in the Just Transition Task Force with the Under 2 Coalition. The initiative aims to accelerate progress toward a low-carbon, equitable economy by framing government action and just transition through a working group to sustainable subnational governments dedicated to strengthen just transitions efforts. The coalition members who signed the Under 2 Memorandum of Understanding of 2021 include Quebec and committed to achieve carbon neutrality by 2050. Another example that I want to give you is how Quebec is determined to fight climate change and human rights at its scale with the SEGA project. The FAO and the government of Quebec have joined forces with the government of Senegal and Haiti to support the implementation of the adaptation component of the national determination contributions and the integration of agriculture in national adaptation plans. The SAGA project supports the two Francophone least developed countries, a small inland development, Haiti, and the sub-Saharan African country, Senegal. In both countries, climate change poses immediate and serious threat to food security, nutrition, and livelihood. On the ground, the program has implemented a broad range of initiatives and trained more than 2,000 small-scale food producers, engaging them in activities ranging from market gardening to animal husbandry, agroforestry, and much more. These small-scale food producers are equipped with the knowledge and skill to share this experience with the beyond the communities. But let's stop bragging about Quebec and let's focus on this panel and human rights. Climate change is real, and the human-made greenhouse gas emissions are its primary cause. The increasing frequency of extreme weather events and natural disaster, rising sea levels, floods, heat waves, water shortage. We experienced the low ice coverage here in the Great Lakes region like this winter. These phenomena directly and indirectly threaten the enjoyment and the range of human rights by people through the world, including the right to live, safe drinking water, food, health, housing, self-determination, culture, work, and development. The negative impacts of climate change are disproportionately borne by persons and communities already in disadvantaged situations, owning the geography, poverty, gender, age, disability, cultural, or ethnic group background. These persons or communities have historically contributed to the least to greenhouse gas emission. The preamble of the Paris Agreement to the United Nations Framework Convention of Climate Change makes it clear that the states should, when taking action to address climate change, respect, promote, and consider the respective obligation on human rights. As the Human Rights Council has stressed, it's critical to apply a human rights-based approach to guide global policies and measures designed to address climate change. The Council recognized that the rights of people in vulnerable situations were disproportionately affected by the negative impact of climate change. Let's now talk about the Canadian and American perspective and the collaboration of countries regarding this I mentioned earlier. To combat climate change and demonstrate global leadership together in the face of the climate crisis, Canada and the United States have decided in 2021 to launch a high-level dialogue. Both countries are committed to invest their joint efforts to combat the climate crisis and increase the economic benefits of working together. Canada and the United States share an interest in increasing climate ambition to ensure the global competitive net zero North American economy. Ultimately, this collaboration will strengthen policy alignment on climate while ensuring climate adaptation, resilience, security, economic growth, particularly in integrated sectors. In addition to this binational federal effort, I would like to highlight our binational regional efforts through forums like the Great Lakes Commission, which is an interstate agency with representatives from 8 Great Lakes states and provinces of Quebec and Ontario over the past year, We have identified a need to future develop our research in shifting climate, agricultural stresses, and impact on reliance on largest asset in Great Lakes. So I have my engagement that I'm most proud of, like in the Great Lakes region. In March of this year, the Great Lakes Commission passed a resolution highlighting the need to work across multiple levels of government, the nonprofit sector, and beyond to ensure our region preparedness to these new challenges. So today, I will have the chance to be with three great panelists, and I will start maybe with and to introduce them. I know their name are not on the table, but you know them. I will start with Sonia Savage. She's the senior counsel of Borderland Gervais. She's also served as the senior minister for 4 years in the Alberta government. Most recently, she had the position of Minister of Environment and Protected Areas, as well as the Minister of Energy and Minister of Justice. Previously, she worked in the corporate sector as a senior executive for the Canadian Energy Pipeline Association and Enbridge. She earned a Master of Law in 2015, and she had published thesis for focus on the evolving role of the National Energy Board. She's also worked in private practice as a litigator for 13 years. Her outstanding experience regarding energy policy, regulation, climate strategy, and environmental led her to develop her expertise in navigating the balancing energy security, climate interests, and changing political landscape. She will join us today by Zoom, I think. Yes, she's online. Thank you so much. I will introduce our socials before we pass the mic to you, Sonia. I will introduce also our two other panelists. Christy Balzanek is a partner global co-chair environmental, social, and government at DLA Piper, a global law firm with lawyers in more than 40 countries. Prior to joining DLA Piper, Christy served as a general counsel for the North American divisions of two large international companies and as a global corporate compliance attorney of two international law firms. In her most recent role as general counsel, Chief Compliance Officer and Data Privacy Officer of the U.S. Division of Global Grocery Retail Company headquartered in Germany, she oversaw and advised the U.S., European, and Asian management teams on a broad range of legal matters. She also led the management of a company cross-functional business team on ESG-related requirements. Christie's experience gave her a unique and broad perspective on legal, commercial, and operational insight in counseling transdisciplinary legal department. Can't wait to hear from you. And the last but not least, Victor Flatt is Professor, Associate Director, Coleman Beaver Center for Environmental Law at Case Western Reserve University School of Law. Professor Flatt is currently the Dwight Old Chair of in Law and Faculty Director of the Environment, Energy, and Natural Resources Center at the University of Houston Law Center. He's recently mainly focused on environmental legislation and enforcement, and more precisely on the practice of environmental markets such as carbon trading, which is something of very interest of Quebec. Yeah. Some of Professor Flatt's many accomplishments include co-authoring legal protection of environment and authoring over 50 law review articles with apparent journals such as Notre Dame Law Review, Ecology Law Quarterly, and the Washington Law Review. So I will start the panel with Sonia, if you, Mike, as you are online. The mic is yours.
Sure. I hope. Can you hear me?
Yes, we can hear you pretty well.
Oh, excellent. I'm always thrilled when technology works, and I wish I'd been there in person with you today. But coming from Western Canada, I just couldn't make the travel plans align with events on both sides of this conference. So I wish I could have been there in person. But in thinking about where to focus on and how to approach the topic, the very important topic of climate change and how it's impacting human rights, I thought I would come at this topic from a slightly different angle than the other panelists, and thought I would come from it from the vantage point of someone who was tasked with developing and implementing a climate change plan and dealing with the complexities and the competing interests and objectives that governments have to deal with as they're dealing with climate and looking after climate ambitions targets and the urgency of addressing climate. My background, as mentioned, is I served as both the Minister of Energy and my last portfolio in the Alberta government was the Minister of Environment. And my very first task after being sworn in as the Environment Minister in 2022 was to develop and draft and come up with a net zero climate plan, one that balanced the need to urgently address emissions and to address global climate change, but to balance it with other important objectives that the province was seeking to balance, such as energy security, affordability, and reliability of energy supply. Of course, this wasn't an easy task. As many of you know, Alberta is an energy producing province. It sits on top of the third largest reserves of oil on the planet and is the fourth largest oil producer and the fifth largest natural gas producer globally. So developing a plan with a net zero aspiration at the same time as balancing the other important economic and geopolitical issues was not going to ever be an easy task. It never is for any jurisdiction, and especially not for an energy producing jurisdiction. It was also not easy in Alberta because there's, as many of you know, there's always an ongoing dispute, and there still continues to be between Alberta as a provincial subnational government and the federal government over jurisdictional issues and constitutional jurisdiction over energy, natural resources, and environment. So when we started drafting a plan, we started with the very first question. The most important question is, can we realistically get to net zero in the province of Alberta? Alberta has most of the emissions in Alberta are industrial based. I think between 60 and 65% of the emissions are not from consumer use, but from industrial based, whether it's oil and gas production, steel, cement, electricity generation. And in Alberta, we weren't blessed with a mix for electricity that included hydro and nuclear. So we had a challenge right from the beginning. And we asked the question, can we get to net zero by 2050? And we looked at everything and we said, yes, absolutely we can. But it depends. It depends on a lot of things that are somewhat out of our control, like new technologies being able to scale up and commercialize and scale up. It requires, for decarbonization, a lot of mobilization of capital for transition technology, infrastructure. We have to be able to have regulatory processes that are nimble enough and fast enough to rapidly build out energy transition infrastructure. And of course, on top of that is supply chains, labor change. So we said, yes, we can get to net zero, but it's possible, but there's a lot of things outside of our control. So that leads to the next question we had to deal with is, do we legislate the net zero target, put it into legislation like some other jurisdictions do, and do we set interim targets? And the answer to that we came to was no. And that was predetermined by the first question. It's possible, yes, to get there, but there's a lot of things that were outside of our control. And for us, we considered it would be irresponsible to legislate something as a government that you don't know if you can actually meet yourself. And we see that around the world globally a lot. And in our own country, in Canada, we've never actually met a climate target. We see it pretty much all around the world with those who legislate climate targets and bring in interim targets. For one reason or another, they can't meet them. And we thought, we're not going to expose ourselves purposefully to climate litigation that we don't, it's not within our control whether we can actually meet our targets. So that was the second question, is to whether we would legislate or not. And so instead we set an aspiration for net zero target with an aspiration and a plan to develop sector by sector assessments of technology pathways, costs, timelines, policies need to incent, determine how much it was going to cost, who was going to pay for it, what percentage would be paid by industry, by consumers, by governments, and that work is underway. I didn't run in the last election. I left the government in about this time last year, June of 2023, and those processes are underway. Now, when we announced our climate plan, it was about a year ago today, we did have criticism for not having interim targets and not legislating. Our response on that was, there's a lot of places around the world that legislates. Russia has a legislative target, but does anybody really believe for 2 minutes that Russia has will be bound by that legislation. So our next step in doing the climate policy was to develop some principles and guardrails around how we're going to balance all these competing interests, affordability and reliability. Because we can't develop climate goals that are going to compromise the ability for the population to have affordable and reliable electricity. We can't put ourselves in energy poverty. We see what happens when governments do that. They have to fairly quickly retread to meet population's expectations. And we also wanted to make sure that we were giving appropriate consideration to energy security and geopolitical considerations. That being, our climate goals shouldn't compromise global energy security or global security in general. And part of that was around the thinking, if we don't develop our resources here and we leave our resources in the ground in Canada, in Alberta, it'll just come out of the ground somewhere else, places like Russia. And that would be just not only displacing the emissions from here to other jurisdictions, but in many cases it would be transferring economic power and global security. So I mentioned these guardrails that we considered because so often, and especially when we talk about climate plans, and as it relates to human rights and social justice and fairness and intergenerational fairness, and also in the context of climate litigation, we quite quickly forget that nations and governments that are implementing climate plans they can't develop it in a vacuum. They're having to develop those policies with the consideration of other economic and energy policy and global security. And we've seen it over and over again, examples where we're seeing it in litigation. Countries that can't live up to their legislated or their climate objectives, we're seeing litigation, and we're seeing it politically. Examples where countries are having to admit that they can't meet their targets and timelines and specific policies meant to accelerate transition. We see that globally. We saw it recently in the United States when, after Russia invaded the Ukraine, and energy security issues coming to the top of the agenda. And we did see at that time the Energy Secretary Jennifer Granholm ask for increased production in the United States. So that's always a concern when you're implementing policies. Is are you implementing something that's impossible to meet? We also, front and center, and we're hearing more of it globally and particularly in Canada, concerns about affordability in relation to climate change policy. We saw it recently in Canada with the federal government withdrawing the carbon tax on home heating fuel in Atlantic Canada after a very strong outcry from citizens in Atlantic Canada about the cost to heat their homes. So that's sort of a stark reality of what happens when your climate ambitions hit reality that you can't implement them, and you find out pretty fast that reality has sharp teeth. So there's also the energy security interests, and we saw that particularly 2 years ago, after Russia invaded the Ukraine, and the need to weed out Russian energy from the supply chain was very stark. That had to be. You clearly don't want to have your climate plans and policies just result in giving a strategic and economic advantage to hostile countries. And we were pretty vocal on that in Alberta, that energy security needed to be considered. And so much so that back in 2022, I was sanctioned by Russia and a number of my colleagues in the Alberta government were put on the Russia sanction list. So apparently we can't travel to Russia. A lot held that as a something that they were quite proud of. But it's a reality that if you're gonna look at energy security, sometimes that's going to happen. And one last point, because I know we're running out of time. I just wanted to talk a little bit about, impact of climate change and human rights. And that's extremely important. And it's usually we talk about that in the context of social justice, disadvantaged communities, future generations, the right to a healthy environment. And we are seeing some climate litigation in Canada moving through more recently through the Federal Court of Appeal in Canada. It'll be moved along to the Supreme Court on climate litigation in regards to the Section 7 charter rights to security of the person. But I just wanted to note again that we can't address. Sometimes we have to acknowledge that we can't address climate change and the specific policies we implement without looking at the broader other economic things, energy security, reliability, affordability. So I want to make one last point before, because I don't know if we'll get to it in the questions, but because it impacts human rights, and that has to do with having the goal to have a clean electricity grid, a net zero grid by 2035, and to have electric vehicle mandates by 2035. And we all want to get there. We want to get there rapidly, but we have to be cognizant of whether we can do that in that accelerated timeframes within the context of North American supply chains for critical minerals, for mineral processing, for manufacturing, battery development, electric vehicle manufacturing, because China is far ahead of us. And if we're trying to meet some aggressive timelines, the only way we can do that is to rely upon their supply chains, which of course it's pretty obvious there's some human rights considerations in that. So I only make that point because there's a balance of protecting human rights with aggressive climate policies, but you have to also look at the other end of what potential human rights and economic and security interests you might be coming out at the other end. So I'll leave it there and look forward to the conversation and the questions. Thank you.
Thank you so much. Thank you so much, Sonia. I very appreciate your comments. I'm going to go back to you for question after we go to our next presenter. Christy, if you want to go ahead.
Thank you. Thank you so much, and really appreciate the opportunity to be here today. My name is Christy Balsanic, and I'm a partner with DLA Piper in Washington, D.C. So I really appreciate our partnership with our colleagues with Rick Newcomb and Ambassador Jim Broadband for the invitation to come here today. As was mentioned, I'm also global co-chair for environmental, social, and governance. So these topics are very close to what we are advising companies now on these really important issues. And before I dive in, I'll just also add, because I am coming from Washington, D.C., that I actually have 3 really important touch points with being here as well. The first is that my parents are from Michigan, and we actually lived in Akron when I was a young child. I don't remember it, but I did live here, and it's actually my first time in Cleveland, so it's really been very special to come. Number 2 is that the Canadian connection is that when I was in-house as a general counsel with Gate Group, which is an international airline catering company headquartered in Zurich, I was a North America general counsel, which meant I oversaw not only the US, but Canada, which meant I went to Toronto very often, to the point where I had to get a work visa to get into the country. So that's number 2. And then number 3, in my 20s, I was actually a Peace Corps volunteer with the US program that sent me to China to teach English at a teacher's college in the middle of Sichuan. And it was a tremendous experience in the late 1990s to see where China was then and see where it is now. But while I was there, saw firsthand the environmental degradation and the impact on communities for where China was at with their coal and other mining that was happening, to the point that I actually had developed asthma the entire time that I was there, and many of the other volunteers did too. Thankfully, I don't have that any longer, but it's certainly something that I think about in terms of the impact. And sitting in the US and sitting on the East Coast, of course, we were experiencing the heat wave firsthand. We experienced the smog and smoke from the wildfires from Canada as well, and just all the changes that we do see. So right now, in the role that I have at DLA Piper, thinking about how to help advise the role that companies play, and particularly international companies in this space. And I can tell you it's been tremendously dynamic, just the changes that companies are going through with these navigating of various laws and what the framework looks like. So I'm here to give the U.S. perspective, and we're going to speak about three important topics. First, what is happening at the U.S. federal and state level on climate and impact on human rights. The second is the role of companies, and where do companies fit within this framework itself? And then the third, as was mentioned earlier, is litigation, and the tremendous increase in litigation that we see here in the US, and I know we'll be discussing at the global level with our next panelist. So speaking of the US right now, you may be aware that the US approach, particularly at this moment under the Biden administration, is very much in contrast to what we would see perhaps, I know we're here talking for Canada, but just to compare as well to the European Union because of the Green Deal that you may be familiar with, which is quite broad, and they've set a course that they are trying to pursue. In the US, it's been a little bit different. And essentially right now, we do not have this overarching mandate to achieve certain greenhouse gas emissions or other types of climate goals. Essentially, what we have is that the Biden administration, well, they've set a goal, and that's through the UN. For those of you who follow the UN framework on the Convention on Climate Change for the COP, there is a set of reports that countries do submit through their NDCs, which is their nationally determined commitments. And so the Biden administration, the goal that was put forward for Dubai just this past December related to the goal to reduce greenhouse gas emissions in the US by 50% based on 2005 levels, and that would be done by 2030. So that's this overarching piece. So how would the Biden administration think of getting there? Well, at the federal level, there's a real focus right now to incentivize companies to get there. And you may be familiar, of course, with the Inflation Reduction Act, which put forward a number of subsidies and other tax credits, incentives around solar and EVs and wind and renewable energy and so on. And also it's the bill, the bipartisan infrastructure law as well, that was in tandem with that. So at the federal level, this is all moving forward, but as you might be seeing from the election, which we're experiencing now, a lot of that impact of these very significant programs, of course, we may not actually feel for some time, but that is what has been set in motion. So we'll see where that all leads, but at the time, this is where the focus has been. In addition, there's at the community level, our EPA, Environmental Protection Agency, is very strongly advocating for environmental justice, EJ, in its assessment and how they are wanting for companies, agencies to really think about where EJ, where environmental justice sits into this entire transition and what changes may be made across the U.S. in different communities that have been very hard hit and very difficult challenges that they face. So environmental justice is something we are actually also through companies that are now really looking at their environmental justice programs and thinking through with working with the EPA on this. So this is something that's very much being advanced that we're seeing in the US as well. At the state level, well, it's a bit of a patchwork, as you can imagine. You know that we have blue state, red state, and not to try to politicize any of this, of course, but it is a reality that the US, we do have some states that are, for example, in the real estate and construction side, where they are putting forward new laws that require new companies on construction to have cuts in their greenhouse gas emissions, fossil fuel bans. There's different benchmarking and reporting requirements on new construction. So a lot of in the real estate market, really looking at how to navigate that in certain in certain states like Boston and in Massachusetts, for example, has a new law that they put into place on this topic. So that's something to really keep a close eye on the real estate piece across the U.S. Of course, in California, that's no surprise. It was mentioned about the EV mandate. California has one as well for 2030. That would be 100% green at net zero, 100% for new cars and light vehicles. So there is, at the state level, a lot of different movement on the one hand, and of course, on the other side, of course, there's an anti-ESG movement in other states where attorney generals are sending letters to certain asset management or to investment firms, insurance companies that are opening up the allegations around antitrust issues, around conflicts of interest. So a lot of investment managers are trying to navigate this dichotomy across the states. So it's quite dynamic, and of course I'm speaking right now in this month of this year, but of course we'll see as the election comes next year during your meeting where we'll be because of difference in approach on these topics that are really going to be impactful. That's at the federal and state level. For the companies that are trying to navigate this, so as we know, and we've discussed earlier, there has, of course, been companies that are looking at this from a voluntary standpoint. All the voluntary frameworks, the treaties that are out there, the UN guidance, the OECD guidance, and such related to responsible business with response to climate, human rights, and so on. And so these voluntary framework that companies have been operating under, of course, it's turning into mandatory requirements, and they're having to really shift over how they're thinking about their priorities, because each company has their own priority, as well as what they may have to disclose or report. So it was mentioned earlier about sunshine and how sunshine and transparency can help move information out to all different aspects of investors and customers, employees, and so on. But the reporting and disclosures, again, coming out of the EU on sustainability, on climate, and on these social aspects, this is coming, and a lot of companies are trying to understand what they're going to have to do in terms of data gathering. And if you think about what companies go through with their financial data and the rigor that they take to think about what they're going to disclose in reporting, that's what companies are going through now with non-financial data, and how that's going to work going forward with all these data points that are being really demanded and the scrutiny that's going around on that point. So in the US, right now, we don't have a same broad disclosure requirement, but you may be aware that our US Securities and Exchange Commission last month in March approved a new rule for climate-related risk disclosure for public companies. This was very controversial. It was actually proposed 2 years ago. It took 2 years, 16,000 comments or so later that it was finally approved. And of course, the day it was approved, there was a lawsuit, and there's been about 8 more. Now there's 9, and it's been consolidated into one lawsuit, and the SEC, as you may know, has now voluntarily stayed the rule. It's on hold, not because they're concerned that they don't have the authority, but they are going to defend it, and they want to provide that to focus on and go forward. So we'll monitor that to see where that lands. In the meantime, companies are thinking about how to prepare and how to compare that with other rules around the world that do require this type of disclosure. In addition, if any federal contractors, so the government, when we were speaking about the government is looking to hold its purse to help also influence the activity around climate and, of course, the impact on communities, and that is for federal contractors. Certain ones may also have to disclose, again, around greenhouse gas or climate. It's a proposed rule as well, but it's an important one to watch, particularly because with the election coming, a lot of agencies want to finalize their rules so that they can put that in before potentially there may be a new administration. So where does that take us on human rights? Of course, supply chain due diligence, human rights due diligence, where that is, for us in the US, we don't have a mandatory due diligence disclosure, but what's really important is that companies are, through their supply chains, the scrutiny that they face is very strong that they need to start thinking about through their tiers how they're going to start looking at their impact on human rights and supply chain as well. So these are all areas that companies are navigating very closely. And what is then the additional challenge is the third piece of this topic, which is the litigation. And of course, because there hasn't been as much movement as certain actors would like on climate, on human rights, the litigation is increasing globally, as of course in the US as well. But I'll just highlight that these cases are really looking to the issue of whether there's a responsibility and obligation by the state, by the governments, right, to protect the rights and human rights to a clean environment. And so the one example that we have in the US is the Montana case, where there were 16 youths that filed a case against the state of Montana a few years ago, and essentially claiming that their constitutional right to a healthy environment was being violated because the state, under their environmental policy, had an exemption for assessing the impact of climate change on energy policy. And so this was a very novel case, and the youths actually won. They won the case, and it's, of course, now being appealed. But it is one that was really looked at to see then what may be coming in terms of other types of litigation. And the only other piece that I would mention, too, is that Vermont also has a new proposed rule that would also actually fine fossil fuel companies for any type of damages that would be caused by climate change. And so these raise really interesting issues of standing, of jurisdiction, of causation, and accountability that's really just getting started. And so there's a lot of discussion still to come, and not only in the US, but of course also on the global side. So I'll just conclude by saying that regardless of what may happen over the next year within the US with the election and so on, because of these other global dynamics that are happening, a lot of companies still are looking towards what they need to be doing on that accountability, and then merging and aligning that with what the legal piece is.
Thank you so much. We're going from the Canadian to the US to the global perspective of the issue with you, Victor.
Merci à Canada et les États-Unis et Quebec pour la chance parler ici. Thank you to Canada, the US, and Kuzli and Quebec for the chance to speak here. I first need to correct my bio so my dean doesn't go completely crazy. This is a problem when you have bios all over the web. I'm no longer at the University of Houston, which is based in Texas, otherwise known as the Alberta of the United States. I am now the Coleman P. Burke Chair in Environmental Law, proudly here at Case Western University. So happy to do that. I've been tasked a little bit with trying to sort of pull all this together as the last sort of panel speaker, and how it connects internationally, the US, Canada, internationally, human rights, climate change, et cetera. Today's lunch speaker talked about how really human rights are inalienable rights, they're foundational rights, and that's true. And yet, from the perspective of attorneys, of course, we see them through a legal lens. And through a legal lens, they look a little bit differently. And around the world, we can see sort of three buckets of the intersection of climate change and human rights. One of the buckets, and probably the most important one, has been to sue to correct harms or emissions that cause climate change under treaty law, international treaty law. A second bucket is to sue under a country or state or other sovereign's own internal laws to protect their own citizens, which may be called a human right or a different right. And then there's a smaller bucket of cases, but one that may be accelerating, that is directly targeting the private sector. And so I want to talk about those three in turn. So if we talk about human rights under a treaty, and treaty law, we need to start with sort of what we're talking about with human rights. And I know you heard this morning, but I just want to remind us. Currently, it summarizes the right to life, right to self-determination, right to a healthy environment, which is a new take on it, right to health, private and family life, right to seek, receive, and impart information, which has been particularly important to Aboriginal groups, and the right to an effective remedy. There's also, of course, rights to non-discrimination, rights to work, rights to freedom of conscience, et cetera, and these can go on and on. But essentially, for treaties, these have to be decided on right at the beginning, right? They have to go into the treaty, and the treaty has to set aside how those rights that are infringed can be remedied. So it's not simply that, okay, we've got a human right to something, and that means whenever it happens, we can correct it. It has to go through a very important process to actually effectuate the language of the treaty. And so I'm just going to highlight about 3 different ones that I think are very interesting, that point us both to the past and the future. The first one I want to emphasize was is particularly interesting, I think, after the last panel, the case brought by Aboriginal folks in Nunavut to and before the Inter-American Council on Human Rights in 2006. This is looked at as one of the first cases to directly say that the impacts of climate change were an infringement on human rights as those were defined under the Inter-American Human Rights Treaty. The spokesperson for this, Sheila Watt-Cloutier, got very far. It got further than people anticipated. The court heard it. They did findings of fact. They found that the rights of Indigenous peoples in particular were being impacted. The human rights were being impacted even more than the other rights of folks as well. In 2019, we saw many cases have been filed, but the UN started to look at a case. There was a push to have climate change looked at as a case of human rights violations before the International Court of Justice. That's still ongoing. Then a case was directly filed under a sub-human rights treaty. The United States is not a party to that treaty, so it was excluded from that. That continues to proceed apace. And also importantly, I think, which is fascinating, is that there was the push that successfully, if you will, got the General Assembly to vote in favor of a right to a healthy environment. And that right to, and that's just in the last 2 years, and that right to a healthy environment has not been fully implemented yet, but in theory, it could be implemented going forward through the Security Council, various other things, and through the International Court of Justice. I think you acknowledge that the Paris Agreement, which is about climate change, enshrined that climate change policies would need to respect human rights, and so mitigation and adaptation would need to go hand in hand with human rights as well. I think the final case that's gotten everybody talking is the European Court of Human Rights recently found for citizens of Switzerland that their government had violated their human rights under the European Court's Human Rights Treaty, that by failing to establish a target to reduce greenhouse gas emissions for their citizens. That's very important because many, obviously, the European countries are party to the European Convention on Human Rights. And so what this shows is that any other country that is going to bring this up, that gets the procedural things right, is likely to win before that court. And the court, what it does is it takes an aspirational goal that Switzerland had under, say, the Paris Treaty, and then says, but this is what you have to do. I mean, they're leaving implementation to the government, but they're saying you must put in a plan that will hit a 1.5 degree reduction, considering Switzerland's part of that, as consistent with the Paris Agreement, which is the biggest goal under the Paris Agreement. So we've also had many cases coming under countries' own rights that sometimes are called human rights, sometimes the right to a healthy environment. Australia, there was a very successful case there 2 years ago. You talked about the Montana case. The Montana case is sort of was a surprise, especially after something in the United States called the Juliana case, which had youth suing the federal government in federal court about the right to the clean environment, the right to have the United States take into account climate change under their human rights, essentially the Due Process Clause of the United States Constitution. And these are going, I think, we've seen these accelerate, they're going to continue. So not only do we have multiple litigation under the treaties about human rights, but we have multiple litigation under the local constitutions or charters of various countries, states, et cetera. And then I just want to mention briefly, because you mentioned the private sector, we've had a couple of cases. The most famous one is from the Netherlands, the Urgenda case, where the court there actually held that Shell was liable for causing harm to the public there through its emissions. Of course, Shell was at the time based in The Hague and then relocated to London immediately thereafter. But they were told by the court to reduce their emissions up to 45% over a certain period of time. And of course, there are many in the United States, especially because we have so many jurisdictions, private cases now that are seeking to hold fossil fuel companies in particular liable for harm they may have caused to persons, to countries, cities, counties, states that have to spend money to comply with this. Most of those are not based on human rights law in this country, but around the world, some of them are based on a human rights law. And the last thing I will just give you is I looked up the numbers related to this on the Sabin Center's website at Columbia University. In terms of the rest of the world, not the United States, we've had 167 cases filed against governments based on violation of human rights in relation to climate change. Of those, 37 are rights to a healthy environment, 19 are youth and children, 6 are climate migration, 2 are women's groups, and 10 are Aboriginal or Indigenous groups. So this is not a tiny thing. And again, from a very small seed that really was theoretical until the court let it move along a little bit in 2006, we've really seen an explosion. And that explosion affects governments, it affects our conception of human rights, and it affects the private sector as well. So I'll stop there.
Thank you. We have some time for questions from the audience. If some people have questions, I have some as well, but if there's mic on both sides, please don't hesitate. As we're moving, Sonia set kind of the stage when she mentioned how our government, when she was a minister, decided to not legislate and take other options to tackle climate change. You, on your side, I think it's interesting to see how things are attached together, like with what you're mentioning, Christy, with the obligations of companies as well, we have to tackle the issues, and what you just said also, as a stage. What is the limit, I would say, of the obligations and what are the consequences when you don't meet these obligations that you're setting? You mentioning this case that happening, like Alberta not moving forward in that direction because they were concerned about it. What are the real consequences, the legal repercussions?
Just briefly, I'll start and pass it on to you. No, that's really important, and particularly going back to ones that are brought under treaties. Obviously, the remedies are only as good as what the treaty can set out and what they can do and what they can enforce. Yeah. And some treaties have greater power. They've been given greater power. The European Human Rights Treaty, I think, is probably most effective at this point because of its interties with the market and countries participating in that, and as well as the European Council. Certain things, for instance, had the Inter-American Organization for Human Rights determined that there had been a human rights violation, its and that the United States had done that, it is unclear that that would have affected anything.
Yeah.
And so it really is going to depend on the enforcement mechanism within the government, and specifically the ruling tribunal, whether it's one created by treaty or one created within the framework of the country, state, et cetera, as to what their powers are. And historically, and one of the reasons we've seen an issue with climate change litigation, historically courts have been very reluctant to actually order direct emissions reductions for countries or private organizations, more for private, they're particularly don't want to do that for countries. But what we see in the Swiss case is that's starting to change. And so what used to be seen as more powerless, I think, is now moving in the direction of actually having some teeth.
No, and picking up on that, what was very interesting in the Swiss case is that typically, my understanding, again, not being a European lawyer, but just that there was automatically be a deference as well to the state and their decisions, of course, right? And so, and right now, particularly in the US, I mentioned with the lawsuits against the SEC and just the challenge of authority there. I mean, the EPA, there was a Supreme Court case with West Virginia versus the EPA as well. We have our Chevron decision that may be coming out in the next few weeks or months or so. And just really thinking about that exact point and where these authorities will lie and what kind of challenge that will be. In addition, yes, the same regulatory framework in terms of liability for companies that face either regulatory enforcement, whatever that regime is, or at the state level. For example, now in California has bills that are requiring disclosure on greenhouse gas emissions and climate-related risk, as well as if you're using carbon offsets and credits, they want you to report it on the website. And so there are repercussions there, even potentially to the Attorney General level. So you really need to think about all these different dynamics that are coming in, and then across with the litigation as well. We haven't even talked about the greenwashing situation because there's so many different pieces with that. Starbucks, for example, has a case in courts in Washington, D.C., greenwashing, where they, of course, if you go to Starbucks website, they'll talk about their human rights commitment, but the allegations, at least in the complaint, relate to forced labor claims across their cocoa farms. So just thinking through how all of this is interplay, it's just a really dynamic discussion, so that's where we are.
Just want to know if Sonia is still online with us, if she wants to jump on it as a company answer.
I would just add again that it's difficult when jurisdictions, whether it's a subnational or a national or even a municipality, are setting targets. I think they have to be really cognizant and careful to set targets that they have a chance of meeting, and or they set themselves up for additional litigation along the lines that you set a target and you can't meet it. And I only just point out one other thing, because I think we've had a lot of conversation on it. You don't see any climate litigation against China or Russia or Middle East countries or some of the largest emitters out there, but you see them against democratic countries that are taking environmental responsibility seriously and doing the most to address climate change. So I would just point that out, that there's little countries and jurisdictions that are getting sued are not necessarily the ones that are the largest emitters and the worst actors.
Well, and also Russia and China are not party to most of the human rights treaties internationally. So,
yeah.
Yeah, thanks. Great panel, really riveting. I have a couple of questions. I want to get your take on the current, for example, the USMCA environmental chapter and other environmental chapters that are being negotiated. We haven't heard anything about them. Are they kind of already out of date and antiquated, or are we looking at ways of revamping or reinterpreting the spirit and intent of these chapters? I just want to get your take on this, because of course there's an awful lot of work putting into it, but I'm not seeing an awful lot of results on that. So is that because it's working well, or because it's been sidelined because of other ongoing events?
Well, if it's updated, it's up for renegotiation 2026. So.
Yeah, and I hate to call it the USMCA because it just annoys me so much that
I call it
They couldn't
NAFTA.
just call it NAFTA. Anyway,
Yeah.
so you know, in theory, the provisions in the USMCA were better for the environment, including climate-related issues, but it's already out of date, for sure. I mean, everything has accelerated so much in terms of like border adjustments, in terms of taxes, or carbon trading, or you know, goods moving and their carbon content. All of that is just, it needs, yes, that needs to be addressed.
Agreed. Not much more to say, unfortunately.
Sonia, something to add? Nope.
Okay,
Yep.
I've got a question for Sonia, and then for our two lawyer panelists as well, okay? And that is, there was a book came out recently called Fire Weather. It was about the huge forest fires in Alberta. And the book makes the point that the activities of extracting oil from the oil sands is generating the environmental climate change that has led to these huge uncontrollable fires. And so my question is, are you seeing challenges to liability to the actors in Alberta, and then you know, to you two on the panel, Victor and Christy, what are the theories of liability that would, you know, that plaintiffs can make in these environmental claims? So.
I guess I would start out with emissions don't have boundaries. So emissions that come from Asia are just as damaging to our environment here in North America as are our emissions in North America. And we did see some very devastating forest fires in Alberta. But I would also point out that our oil sands producers in Alberta are on a path to net zero. They have an $80 billion project to decarbonize and to get to net zero production out of oil sands production. I don't think we're seeing that we're certainly not seeing that out of Russian production or necessarily Middle East production. So, but I would just point out that there aren't boundaries for emissions. But in Alberta, I think more what we're seeing on climate litigation is more around litigation to stop projects when they're in the regulatory phase, and to whether it's pipelines, whether it's new production coming on, whether it is the environmental assessment legislation. That's where we're seeing more activity in Alberta, that and corporate resolutions and some actions, activist shareholders resolutions from corporations.
So in the United States and in common law countries, the primary mechanism for direct litigation is under tort theory. It used to be almost all nuisance. Now it's also product liability, trade information, misinformation, deception. And as you point out, as she pointed out, you know, the emissions come from everywhere. But from a tort theory, that means the emissions are well mixed. They have the same effect. Yes, so in theory, liability could be subdivided by sort of amount of emissions, depending on where they come from, but we just haven't gotten that far in testing that theory yet. And I think one other point I will make, and I'd love your response to this too, you know, we're not going to stop natural gas and oil right now. We can't. It would be literally impossible. It would be our world couldn't function if we just said tomorrow, no more oil or no more new oil. So we're obviously, what we're disagreeing about is sort of how fast that transition is supposed to occur and what our goals are supposed to be. And one of the things we are seeing is the private sector and government-supported private sector has exhibited a preference for what I would call more low carbon emissions. So Alberta sands, methane from the US fracking when it was regulated, then the minute the Trump administration removed that methane regulation, you know, Energy in France withdrew its $6 billion contract with NextEra to deliver because it was no longer good natural gas. So we're already seeing that discrimination happening to, in theory, reward the companies that are producing this and either offsetting or producing it with less emissions.
Yeah, I think, covered what the different theories of liability are in terms of tort negligence and such. I think the causation issue is a fascinating one, and I mentioned that Vermont, if that bill goes forward, and how is Vermont going to measure?
It's get over that
Yeah,
causation
just
problem.
how, and to figure out which companies will have to pay those damages. And then if you look at, companies on their own or voluntarily, you can go to all of their sustainability reports and see what their goals are in terms of what's coming up for 2030, 40, 2050. And watching, too, what's happening with COP. There was about 100,000 different participants there. The business presence in Dubai this past year was quite significant. So this whole mix that's happening to make all this happen, we'll just have to continue to see, but certainly going forward.
I just want to have one last word. I think the reason we're seeing the acceleration, both in human rights and both other litigation, is because the impacts of climate change are becoming much more obvious and are accelerating. And I think those things go hand in hand.
Agreed.
Well, we already reached the end of our panel today, but I want to thank our panelists. I think there's a lot of questions that I think the audience still have, and I had some other, regarding USMCA, where we can tackle these challenges together, making sure that we are building a greener economy, in the region, we mentioned in water a few minutes ago, here in the Great Lakes region. I think that would become a very interesting conversation in the upcoming year between Canada and the U.S. Yes, we sit a lot by the bank of Lake Erie, where there's 20% of the fresh water of the world, but at the same time, we're experiencing some droughts, already the fires that you were mentioning happened also in Quebec last summer. So a lot of other issues and things to tackle, maybe for the next conference. Thank you so much.
Good, yeah,
Thank
thank you very much,
Thank you.
Jean-Francois. Victor, Sonia.